Hello, I'm here to teach you all about surrogacy in Canada and what you can and cannot do. This is not legal advice, but you can use me as your lawyer. Is surrogacy legal in Canada? Yes, but it is restricted, for example, payment. You might need a surrogate if you are a single man, a gay couple, perhaps you're a couple who faces infertility, or you're just someone who requires the use of someone else's uterus in order to have your family. There are plenty of reasons why you might not be able to do it yourself. For example, your medication for your mental health might be incompatible with being pregnant, might have a pre existing health condition. Anything like that could cause someone to require the help of a surrogate. Surrogacy is very complex and controversial. Certain religions, like the Catholic Church, have denounced it, and there are certain countries in the world that have made surrogacy illegal. Here in Canada, surrogacy that is unpaid, which is also called altruistic surrogacy, that's the only permissible type of surrogacy. That doesn't mean that your surrogate won't get coverage or reimbursements during pregnancy. It's estimated that a surrogate will incur somewhere between $25,000 and $45,000 worth of expenses during a pregnancy. So things like maternity clothes, exercise classes, medical appointments, the transfer and pre-pregnancy workup and screening, and legal fees as well. There are also restrictions on work. So, for example, if a surrogate is placed on medical leave during their pregnancy and they have a job, they can receive payment in lieu of that paycheck. But this would require a doctor's note saying that they are unable to work. There is room for improvement in the reimbursement of these expenses and how it works in practice. This has been an issue since the Assisted Human Reproduction Act, or the AHRA. For a number of years, it didn't explain what the expenses were, which led to a number of years expenses being in a gray area where no one, including lawyers, knew how to advise clients, and nobody knew what the actual allowable expenses were. Now we do. If your surrogate is based in British Columbia, it's best for you to have a contract that is based on British Columbia law before you get started. This would be something that is in line with Part 3 of the Family Law Act, which provides the framework for determining parentage when there's assisted reproduction being used. So, Section 29 of the Family Law Act outlines the requirements for surrogacy agreements and what provisions need to imply, like a written agreement. So once you find your surrogate, you need to make sure that all parties have participated in the necessary screening. It's standard practice before anything happens in the clinic. The surrogate and intended parents should undergo necessary medical and psychological screening. Independent legal advice for the surrogate to ensure informed consent and protect their interests. Recently, there have been some updates in mental health for surrogates. So the research coming out of the universities, there was a big study in Ontario, looked at 767,000 pregnancies, found surrogates were more likely to be diagnosed after birth compared to people who had gotten pregnant on their own or those who used IVF. About 7 out of every 100 surrogates were diagnosed with a new mental illness compared to 5 out of 100 from other groups. There is a notable bump in risk for surrogates. If you're thinking of surrogacy or supporting someone who is, it's important to pay attention to mental health before, during, and after the pregnancy. Extra support and regular check-ins make a big difference. It's best practice to treat them with utmost care. Keep receipts of the expenses that your surrogate is having, even if for $20. So you will want to have anything and everything documented. It's best if you can't do something for a doctor to confirm that. And yes, it is very time consuming. So this is another reason to be supporting your surrogate and to be helping them throughout, checking in, asking how they're doing, and whether or not there's something that you can help them with. This can be difficult when you're from another province or country, but it is best practice. What are the rules if you have a surrogate who gives birth here in BC? What you're going to do post birth will look similar to someone based here. As soon as your surrogate is able to, you will have them sign a document, a statutory declaration from Vital Statistics that will just confirm what you've already hopefully gone over in your gestational contract, which will be them giving you parental rights. As the intended parents, you're also going to be signing this statutory declaration. The notice of birth will be sent from the hospital, and those will all be sent in order to have the birth certificate created and list the intended parents instead of the surrogate as the birth mother on that long form birth certificate. If you're coming from another province in Canada, it would be best to have a lawyer look over your jurisdiction to see if you require any extra steps, such as a parenting order by the Supreme Court of BC, whether or not that's required or recommended, just as extra evidence for your province that you are the parents of this child. In terms of what BC is doing and how our parenting issues and parenting declarations are going, Section 3 of the Family Law Act in BC underwent a review in 2024, a report, and now we're looking at potentially changing things. So it's easier to get parenting orders after birth, something similar to a desktop divorce. And this report also talked about assigning post-birth decision-making power to intended parents. But it is written out in the Section 29 that it is possible that as long as everything is in place, you can just go ahead and be considered the parents. There are provinces that require parenting orders like Alberta and Nova Scotia. If coming from another country, you'll need a passport for your newborn. Be prepared to spend time pre-birth and post-birth. If you have a visitor's visa, that might mean that you need to get that extended if you're still waiting for the birth certificate, and you will apply for that passport with the birth certificate. It really is dependent on your home country's laws, whether or not you'll need a parenting order in addition to the birth certificate. Some countries don't recognize surrogacy, and I would be happy to help intended parents that are dealing with any restrictions from their home country. As we know, surrogacy is sometimes the only way a family can create a genetically linked or even ungenetically linked child of their own. And this is something that the Tokyo Declaration, the recent document in the last couple of years by the International Federation of Fertility Societies, the IFSS, and they are global specialists in reproductive medicine. The Canadian Fertility and Andrology Society, or CFAS, co-signed it this summer. And while the Tokyo Declaration says that a country is able to opt out of things like surrogacy or the recommendations within, they don't have to follow it to the letter. However, it does provide that assisted reproduction is a human right. So if you are to come to Canada from a country that effectively doesn't permit you and your partner to have a child through IVF and surrogacy, that would be something to look into. The Tokyo Declaration would be a foundational document because it has aligned international standards on this issue. When it comes to your relationship with your surrogate, it is important to remain respectful. This is not an employee. This is someone who has their own life, their own children, if they've given birth before, which most likely they have, and they are doing a massive undertaking here. They know the risk, responsibility, the process of becoming pregnant and giving birth, and they're doing it for you, which is an absolute miracle and should be treated as such. So this means as intended parents, if I were your lawyer, I would make sure that the surrogate received independent legal advice and that they had the very best screening and assistance for mental health and physical care. When we go through the contract prior to becoming pregnant, we would make sure that everyone is aligned on every single detail. This includes things like where is the birth going to take place? How is the birth going to take place? What will happen around selective reduction if required? In Canada, there's not necessarily a lot of like arguments or litigation that happens between surrogates and intended parents. However, I could see that that could grow with the growing popularity. If you do find yourself in a situation where you need mediation, recommend lawyers like Melissa Selfie. As we discussed in our most recent YouTube video, it sometimes feels like the advice towards both parties feels kind of like employment law, but it truly isn't. This is an altruistic act. The unpaid nature means that it's not someone dictating to another the terms of the agreement. This is a mutual understanding of how everyone will have a say in how it will proceed. So, when it comes to determining things like what is a reasonable expense or an expense that's necessary for a surrogate, we refer to what Sarah Cohen once called the but-for test in surrogacy. So, the but-for test is something like, would they, but for the pregnancy, need prenatal vitamins? The answer is no. If the surrogate incurs something that should be covered, they need to get that paid back by the intended parents. Sometimes they incur costs at a doctor's appointment, like travel, childcare, pet care, and need to get that paid back. I will touch on this at a later time. There are people that leave Canada to seek a surrogate elsewhere. There are wait lists here in Canada, and not everyone is able to find a surrogate that can assist them in a timely manner. So that would be for another video, but also something for you to discuss with a lawyer based in that state or country and can advise you on the laws there and how it might affect your agreement. So for the future, see changes around this process potentially. That white paper is coming out soon. I'll definitely be debriefing on that. And once that is out, we can start pushing for legislative change that will just be recommendations and nothing certain. I hope this video has been clear. The law is not straightforward. Talk to a lawyer before making any surrogacy arrangements in Canada. There are steep fines and penalties, up to $500,000 in fines or 10 years in jail if you are a Canadian who breaches the AHRA. And depending on the country that you're coming from, there could also be fines or penalties. And there's also the risk that they wouldn't recognize your citizenship. So it is definitely worthwhile to have everything reviewed by a Canadian lawyer. If you're having a surrogate who's giving birth here, a BC lawyer. And it is definitely something I would not recommend that people take upon themselves. There's so much room for challenges, complications, and this is an area that's constantly growing and evolving in nearly every jurisdiction. And it is a very recent technology. So it is very important for your parenting status, your relationship with your surrogate, for the good of the child being born. Talk about an agreement with a lawyer. I'm happy to answer questions during my 15-minute consult. You can email me at info@kjadamslaw.com or my website, www.kjadamslaw.com, and set up a meeting. Always happy to talk about this. From the year I started working in fertility as a medical receptionist in Nova Scotia at a fertility clinic, I have seen so much. I've worked with surrogates, donors, and parents nationally, internationally. I also give presentations to lawyers, advice to businesses, and policy advice to regulatory bodies and stakeholders. Always happy to share what I've learned and teach others. Thank you and have a great day.